Morning, everyone. Thanks, Mariah. And thank you, Georgia, for being here. We're really excited to hear from you this morning. Because we have this audience, I am taking every space I get to make sure that this is on everyone's radar. On October 4th, there's going to be a test of the nationwide emergency alert system. So those alerts that come through to your cell phone that will make them blare, everyone's phones are going to be doing that on October 4th. Because of this audience and the fact that so many of you are doing safety planning with people, which often involves hidden cell phones, I just want to make sure that that is on everybody's radar. I'm going to drop the press release from FEMA into the chat so that you can read through that and get an understanding of what's happening. But if you are doing safety planning or working with people who have cell phones hidden in their homes or anywhere for safety, please make sure that they know, regardless of whether or not those are silenced, this alert's going to come through and someone might become aware of the phone that they have. So keep that on your radar. Thank you so much.
All right, Georgia, if you'd like to get started, that would be great. Do you have the capabilities to share your screen?
Yeah, let me, I had everything on my desktop. Let me go ahead and share it and we'll get started. Okay, can everybody see this? And you're gonna have to bear with me because this is not my, okay. Okay, good morning, everybody. My name is Georgia Hensley. I am the Director of Institutional Equity and Title IX Coordinator at Butler University. And I also founded a company that helps educate people on Title IX, what Title IX does, what we can use it to do, and how to work together to support students in this space. To give you a little bit of background about me, I think my first involvement with the coalition was in the spring when I spoke at the conference. And it was an amazing experience. I love the work that you guys do. It was definitely an eye-opening experience. I had a lot of people reach out to me afterwards and ask questions about Title IX and how we can work together. And just having that experience and knowing that there are so many of you that want to support our students and students at other institutions is really really hopeful. And especially during such a time when I feel like a lot of people aren't interested in helping. So thank you all for the work that you do. Okay, so what are we going to do today? First, we're going to talk about what the heck is Title IX, what is the point of Title IX, how does the process work? For those of you who aren't familiar with Title IX, it is often a mystified kind of behind the scenes process that is often very scary for our students, very scary for people helping them and supporting them, friends, family. It can often just be really intimidating. And so we're going to talk about what the heck is it? How does it work behind the scenes? And I'm actually going to let you guys peek behind the scenes. At some point, I will stop sharing this PowerPoint, and I'm actually going to show you our workbook that I created with all of our form documents. And I'm actually going to give that to Kelly at the end of today so that she can send it out to you guys, because ultimately this process is not meant to be scary. It's not meant to be secretive in terms of how it's conducted. And I want you guys to have all that good info to share with your survivors. So the next piece is, what accommodations can complainants, which is what we think of as survivors in the support space, what can they seek and what are their rights? And we're going to talk about that. And then the next and final piece is, people who have my job are often very, let me think of a polite way to say this, can appear very cold. And survivors feel that coldness and lack of receptivity. And so why is that? We're going to talk about why that is, because it's not an unintentional thing. And we're going to talk about how you all, as our community support advocates, can best work together with our coordinators in this space to be supportive of our students, be supportive of these survivors, and really explain to them the role of the coordinator in such a way that the coordinator can also help support the student. So that's kind of where we're going to start today. If you do have any questions at any point, I have allotted a lot of time for discussion because I wanted to make sure that you guys have time and space to ask questions. So what I was going to do is basically stop during all three of these sections at the end and let you guys ask questions. So if you have questions during each section, write them down and I'll stop every time. Okay? Great. Okay, so this is a lot of words, and I know that you're not supposed to do that, but nonetheless, here is a lot of words. So on the screen is the Title IX process for formal resolution. Okay, so Title IX is the federal law that we use to make sure that there is gender equality in higher education. In the 90s, it began being utilized to protect students from domestic violence, which was suddenly seen as a form of gendered discrimination and harassment. So at the point when it began to be seen by the courts as a form of gendered discrimination and violence, so domestic violence and sexual assault, at that point, Title IX was extended to that type of behavior, meaning that universities for the very first time had an obligation to ensure that students were supported and nonetheless had equal access to education in the face of sexual violence or gendered discrimination and violence, which included domestic violence. So that's how we got here. It's this cute little federal law. It's like one paragraph long, and it just guarantees equal access to education for the genders. Okay. And it's expanded in a lot of different ways, but the most important way for the work that we do is this piece, right? Is this piece about extending this protection to students against sexual assault and domestic violence. Okay. When a student has a Title IX case, meaning I receive a report, I first reach out to the student and I ask them to come sit down and talk to me. And we're going to explain each step in this process, and I'm going to explain to you what happens. So right here, the first step in this first little blue arrow is a report is received. A report can literally come from anyone. It can come from your mama. It can come from somebody's Aunt Clary. Get it? It can come from pretty much anyone, okay? It can come from a pedestrian that walks through campus and sees something and says something, okay? Anyone can file a report, absolutely anyone. That report form can be online. We have an online form. Every institution is required to have an online form, so that will not vary, okay? It can come via email, via phone. Every institution has their own set of processes, but we're required under federal law to accept reports from everyone. Kind of complicated, but I'll explain that if you guys have more questions. Okay, so we receive this report. The report usually has the identity of the victim or survivor in it. Sometimes it doesn't. And in those cases, we can't really do anything. A good example, I saw a student get their buttocks grabbed at a party I was at. I don't know who the student was. Well, there's not anyone for me to reach out to figure out who this student was, right? Or I might be able to reach out to the reporter, but chances are if they didn't know then, they probably don't know now. We will do that due diligence to see if that person does know. But if they don't, and we don't know, then that kind of stops there. But assuming that we know who the alleged survivor is, we reach out to them first. In that first email, and every institution is different, but as Title IX coordinators, our job is to make the student feel safe, make the student feel comfortable coming to us to sit and meet. Okay, so often we will say we put very little about the allegation in the email, because it's possible that the student reported this incident to a faculty member in a space of trust, or a friend in a space of trust, and that friend or faculty member or whoever reported it to us. And so to be receptive of the fact that the student is probably dealing with the trauma of not only the incident, but also potentially having a trust relationship challenged by our mandatory reporter requirements, because of that, we try to put as little information in the email as possible so as to not re-traumatize our survivors. That's true of most campuses. The way that our national training companies train us, people who do my job, is really to be receptive to the student, to tell them that you're here to support them. You received a report, be vague, and you just want to talk about how best to support them. And that's really what that first meeting is. We're going to talk about that student's rights, what the student can choose to do during the process, which I'll explain in a moment. I will explain to the student that they have a right to certain accommodations during the process, and we'll talk about those too. Then we let the student pick. They have three options. They can do absolutely nothing, literally nothing. They can tell me that they don't ever want to talk to me again. They're going to forget they ever met me. They can kindly stop responding to my emails. That happens regularly. I don't take offense. They can do absolutely nothing. If a student tells me, I don't want to do anything, I don't want to make a scene, I don't feel comfortable right now dealing with this, guess what? They don't have to. We'll just close that out. The cool thing about Title IX is there's no statute of limitations. So if that student changes their mind during the time that they're at our institution, and any institution, this is a federal law, they can change their mind and come back to me and say, you know what, I'm about to graduate, but I really would like to deal with that. Or, you know, this happened a year and a half ago, 2 years ago. I know I've let it go for 2 years, but I really want to deal with it now. And guess what? I can open it back up, even if that student told me not to do it back then. So ultimately, it's up to the student though. So they can choose to do nothing, absolutely nothing, whether it be for the entirety that they're with us at any institution or just right now. They can choose to do nothing. Second option is they can informally resolve, which we'll talk about in a second. It's like a mediation. It's a powwow, right? We'll talk about that one in a second. It's a nice conversation, a very relaxed environment. These are for our less serious cases. More often than not, these are potential discrimination or harassment cases where somebody said something that offended somebody, and we might just be able to hash it out, right? It's probably not going to happen in our rape, sexual assault, or serious domestic violence cases, right? They probably shouldn't be in a even virtual room together. And we try to avoid that. And then the third option is formal resolution. This timeline that you see from here on out is the formal resolution timeline. This is the most common form of resolution to a Title IX claim that there is. This is the option where the student gives us the complaint, they give us their evidence, and they turn it over to us to investigate. The reason I think this is the most common is students get to sort of take themselves out of it, right? If you've been really seriously traumatized, you can basically perform your part in this in a couple of meetings, and then you get a really long break while an investigation occurs. And students, like most survivors, I think, would kind of appreciate that time to heal. Whereas in an informal resolution, you'd be thrown into even a virtual space with the accused, if that makes sense. So, and I'll explain the informal resolution process in a little bit, but this is the option that's more serious. A formal investigation and formal resolution to a Title IX process is entirely voluntary. There are very few exceptions to that. What that means is if a student doesn't want me to do this, I won't do it. There are very few exceptions to that. If a student tells me, you know what, I don't want you to investigate this, I don't want to informally resolve it, I want to do nothing. They pick the option, I want to do nothing. Well, that's great. For the most part, I can just close that case and that student can continue on their merry way. The only exception to that is if I think that student, that particular student, is in imminent physical danger, or if I believe that the allegations pose a threat to the campus community at large. If it's one of those two situations, which is very rare, and I will give you an example. If a weapon is allegedly in the possession of a respondent on our campus, that's a serious situation. I'm going to have to do something, right? That's an example. Does that happen a lot? No. But that's kind of an example, right? Okay, so if a student elects for a formal resolution process, meaning they chose it, they want to do this, what happens first is they make that decision about how to proceed. That's in our third little arrow here. And then the formal investigation will begin. At this point, the respondent, so the accused, will receive notice. That means that the report has been received. That student, our survivor, has had a meeting with me where they talk about their options, where they talk about the allegations, where they perhaps meet with an advocate, a crisis advocate, where they perhaps talk about missing classes, if they need counseling, if they need any support that I can give them. And they get to take the time to make a decision about how or if they would like to proceed, all before I ever notify a respondent. Okay, so this is a crucial point, because I think oftentimes our students they assume that as soon as the report's received, I'm reaching out to the person who allegedly did something to them. We're not. We will not do that, okay? That is policy, federal law required by the process transcribed at 34 CFR 106.45. We cannot do that until after the student tells us how they would like to proceed, okay? So they get to have all of these conversations with us about supporting them, just supporting them, and making this educated choice before the respondent will ever know that they came to talk to us. Okay, it's a safe time for us in this process. But when this formal investigation begins, I have a legal obligation to notify the respondent to provide him or her notice of the allegations. I have to provide him all of the information that I have been given, meaning that I have to be as detailed as the student has been with me. At that point, we will assign an investigator. These are usually our civil rights investigators. They are trained on just this, conducting bias, non-discrimination, or Title IX investigations, and they will investigate. They will send meeting requests to both the complainant and the respondent. They will ask for evidence from both of those parties, and they will review that evidence and meet with any witnesses to ask questions. Now, common questions that I feel like students have at this point. Do witnesses get told what's going on? Meaning, is the investigator telling witnesses, hey, this was reported? Do you know about this? Did you know that this was happening, right? No. Okay, witnesses are asked, do you know anything about the relationship between these two people? They're not told what the content of the allegations are. They're not told what evidence there is, and they're not provided anyone's point of view or testimony. Okay, so witnesses are just asked open-ended questions. There is no confidential information shared with any witness. Okay, that is important to keep in mind, because I think oftentimes the anxiety of the he said, she said, or she said, she said, or he said, right? These environments can often be very scary, and people worry about what others will say or think. Okay, so it's important to keep in mind and to tell our survivors, hey, we're not telling anyone what's going on. We're just asking what they know. If they don't know anything, they're going to say, I don't know anything, and we're going to move on. So the investigator meetings will occur where the questions are asked. Evidence will be gathered and compiled in an investigation report. And that's right here in this third to last, I guess, bubble. The investigation report is then provided to only the parties, not the witnesses, not your mama, not his mama, not anybody's aunt, no one's professor, just the parties, okay? And the parties get to comment on whether or not they believe the report was accurate. They can provide that commentary back to me, and we will put that in the report. At that point, we check and make sure, this is a matter of practice. I check and make sure everybody still wants to keep going, okay? Often this can be traumatizing. And I like to give survivors especially a moment to say, you know what? I do still want to keep going. This has been a little traumatizing, right? But I still want to keep pushing forward. All right. And if that is still the case, we will schedule a virtual hearing. That's what our campus does. Other campuses may require in-person hearings. We'll talk about a survivor's rights later, but I would encourage all of you, if you get nothing else out of today, request a virtual hearing. Have your survivor request a virtual hearing. Tell them they can make that request. There is nothing that prohibits it. There is nothing in federal law that keeps us from doing it, and most institutions are happy to do it. Even if as a matter of policy, it doesn't say that we have to do it, most institutions will do it, and it's going to make everyone feel safer. So if you get nothing else out of today, on your little notes, write down hearing can be virtual, because it should be, it can be. We should all be doing that. I don't know why anybody doesn't do that. Why would you traumatize these kids? But anyway, I digress. And then after that hearing, which I will explain the hearing in just a second, we get a decision. All right, students are going to want to know who makes the decision. It's not me. It's not anyone in my role. Until October, it's legally impossible that I could be the person making a decision. It has to be what's called an independent decision maker. This can be one person or it can be a panel of 3 people. It depends. Some institutions use a panel every time, some use an independent decision maker. Honestly, it depends. And every institution is different. This person may be affiliated with the university, or if you do what Butler does, which is my institution, we never use anyone affiliated with our institution. These are attorneys that we just find poor, unsuspecting volunteers that for some reason give me their time, right? I mean, you know, I don't know. If you ever want to be one, I didn't say unsuspecting, send me your email. Just kidding. Okay, so again, these are people that are not affiliated with our university at all. If you hear my baby crying too, you all just, this is the modern age. So there's somewhere out here, there's a nanny and a crying baby. So everyone just be patient. Okay. So the decision is issued by that independent decision maker. They will make a decision about not only whether or not they think a policy was violated, so who they believe, they'll make that credibility determination, but they will also decide whether or not to sanction the student. Okay. This means that they will decide if somebody's in trouble and who it is. Okay. If it's not the complainant, meaning if a complainant files a complaint against the respondent, right? If one student is the survivor and the other is just the accused, that complainant cannot be sanctioned. Okay, so a panel couldn't decide, I don't believe the complainant, let's suspend them. Okay, not possible. That's something else that our survivors might want to know. Okay, so then on the screen, I've written down just a few things that you may want to know about our formal processes. And these are just notes that I've heard survivors ask about, okay? The first one is, how long does the investigation take? Well, it depends. I wish I could give you a firm answer, but I can't. Every case is different. Every investigation is different. You want a thorough investigation, so often it can take an entire semester. I want that to be very clear. It's not going to be fast. It's going to be faster than criminal court, but it's not going to be fast by any means. So, good Lord. Number 2, should survivors have evidence? If they have evidence, that's great. Do they need evidence? No. Unlike criminal court or civil court, evidence is fantastic, but it's not going to be necessary. Giving all the documents and recordings and photos to the investigator is important, but the student's own testimony can be enough, right? This is a much lower bar than criminal court, which we'll talk about as well. So during that first meeting, students often get a lot of anxiety as survivors. What happens at this first meeting? Nothing. We are going to talk about the allegations. I provide support. I provide a listening ear. I provide all of the resources that we have at our disposal, both at my institution and in the community. And I give the student the choice. And they don't have to make the choice that day. Like I said, they could take years. They could take years to make the choice. But that first meeting is just talking, just communication, just receiving the information and providing that support. So, oh goodness. During the process, what does the coordinator do? I'm like a referee. I never make decisions. It's not my job to pick who to believe. It's not my job to parse out who is responsible or who's not, who needs to be sanctioned and who doesn't. It's not my responsibility to do those things. In fact, I can't do them. My job is to support everyone and to keep the peace. And peace is misspelled, which drives me nuts. Anyways, what is the hearing like? Okay, do survivors have to confront the accused? Yes, they absolutely do. This is not a court of law. There are not going to be harassing questions. The cross-examination is going to be brief, and I'll give you an example today. It's also polite and open-ended, but yes, you do have to be virtually at least present in a room, right? A virtual space with the accused. And then this last one, where is the hearing? On our campus, it's a Zoom, but like I said, it can be in person. So I'm going to take a second and I'm going to make sure that my nanny is alive. And if everybody could just take a second and think about any questions that you have and drop them into the chat, and I will answer those in 2 shakes.
Oh, we can't hear you, Georgia.
I said, sorry, everybody.
Oh.
Does anybody have any questions? It looks like there are a few, so I'm going to go through them. Okay, so a few questions that we have. First, Marissa made the comment that it seems like a nuanced issue that anyone can report. So the goal is to create more safe campus spaces. So although a lot of these reports are, I would say, discardable for lack of information, having the ability to be able to report, I think, is important just for creating safe campus spaces. And federal law requires us to accept them from everywhere. So although I agree with you, it does end up being a nuanced issue. It's important to know because you may receive information that you want to report. Our survivors may have information that they want to report. And it's important to kind of broadcast that, I believe. Okay, Title IX does not have a statute of limitations, but does the survivor's opportunity to file go away once she graduates? If she returned to school for graduate school, could she file? Okay, so there's a few questions. Your standing to be a complainant for a Title IX process would be limited to your time participating in education. But that doesn't mean, so to answer your second question, if she returned to graduate school, yeah, she could file, right? If she leaves, it's not that she couldn't file a complaint. And under our policy, we also have a more general sexual misconduct prohibition completely. So we can actually revoke degrees and do crazy stuff. But federal law doesn't require institutions to do that, if that makes sense. So it's going to be institution specific, whether or not she could do it after she graduates. If the respondent leaves, it is also up to the institution. So institutions may continue with the process if a respondent leaves, but they may also end the process and just note on that student's transcript that they were subject to a Title IX process at the time that they either transferred, withdrew, or graduated. Does that make sense? Okay, prior to starting an investigation, are you having conversations with the survivors that they can choose between Title IX and legal charges? Well, you don't have to choose, you can do all of it. And yes, and I actually have another slide about the inner workings of a civil restraining order, a criminal case, and Title IX. So I don't want to jump ahead of myself, but yes, that and those options are thoroughly explained to the point that I have actually assigned law student volunteers to work with students on filing civil restraining orders and speaking with prosecutors. So all of these options are explained at the outset. If there's an investigation not following protocol, how can we step in? Okay, I'm going to explain that. I'm going to take a second and explain that and the Know Your Rights section. I don't want to get too far ahead of us because I do have some advice for you guys, but there are things that you can do and things that I want to encourage you guys to do to keep coordinators who are perhaps not on top of things accountable and protect your students. So I don't want to answer that one yet, but we will get to it. So educational institutions have to have a designated Title IX representative, even K through 12. Somebody asked what happens if they don't have one. They do have one. It's federally legally required. So it could be the school district instead of the specific school, which means that if it's a K through 12 space, you're going to report to that district person instead of a school counselor or a teacher or something like that. But everyone has to have one. So don't, you know what I mean? Don't ever think that there's not an institution that has one. You have to have one. So that person is going to be in charge of this no matter what. Investigations are in the K through 12 space, usually conducted by the district, but some smaller institutions or private institutions will have counselors or things like that that are trained to do these investigations. For the most part, you are required to have some sort of training to do an investigation. So it's not just going to be a math teacher on a Tuesday for the first time digging into a sexual assault claim. I don't want anyone to think that. These are trained people who may have other roles, but they are trained to do this job. Okay, can the parties hire an attorney for the hearing? If so, how do you, okay, hold on. Woo, you guys are piling it in. Okay, can the parties hire an attorney? Yes, but it's not called an attorney and it doesn't have to be an attorney. I will explain that in a second. I have a whole thing on advisors. So yes, they can hire an attorney, and there are ways to ensure that cross is brief and flight. First things first, in Title IX, pursuant to that statute that I cited earlier, an independent decision maker must determine that a question is reasonable, is relevant, and is polite and not harassing before the witness can answer it. So I'm going to explain how it works. Unlike a court of law where a lawyer says, and that happened, didn't it? And the witness is like, yeah. Right? Okay. Unlike that scenario, in Title IX, it's more like this. And that happened, didn't it? Decision maker. I don't really think that that question was phrased correctly. Can you rephrase the question so that you're not assuming something that the student didn't say? Lawyer. Okay, what exactly happened? Decision maker. You can answer that. Does that make sense? So not only do our decision makers do it, but I personally, and not just me, but any coordinator is required to monitor the entirety of the hearing. So I sit there the entire time. And every institution has a rule of decorum or a list of rules of decorum for the hearing process. I make my advisors and attorneys sign that agreement. And if they break it, I kick them out. We are required to have that process, and we are allowed to, under federal law, kick them out. And that is something that you can advocate for, which I will get to when I talk about the rights and survivors, the way that we can support survivors. Does this apply to private religious schools? Yes, it applies to private religious schools. Title IX applies to literally anyone that gets any kind of federal funding, which has been extended so far that if you allow FAFSA money, which I think that's everybody, that this applies to you. So yes, Title IX applies to everyone. I know of a school that consistently states they are not required to follow state laws for schools. I think I also know of this institution, and they are also being sued. Anyone can say anything. The question is, are they right? Federal law is pretty clear. Institutions are bound by this. If they aren't bound by this, that means they've made an agreement to not accept any federal participation or funding or any tax exemptions. So I don't know the answer to that, but that would be a unique scenario. Oh, good. Azure is helping me. Azure Swinford is also in the comments. She is our Title IX investigator, and she's amazing. So if she's answering questions, she's helping me. Okay, I'm going to keep going then. And if you have more questions on this, don't worry, there's going to be a time for like general questions. Okay, so informal resolution. This one is a much shorter process. Like I said, there's a lot less time involved. Students must voluntarily participate in informal resolution, and we cannot informally resolve a claim with faculty or staff. So if a student files a complaint against their professor, a teacher, the gym teacher, a janitor, we cannot informally resolve that. We must subject it to the formal process if the student wants to go forward. So meaning if the student doesn't want to do anything, they don't have to do anything still. They can still choose, I don't want to do anything. But if they do want to do something, this is not an option. They have to go through the formal investigation, okay? And that's done, if you guys think about it, it's not done to subject students to a formal investigation. It's actually meant to protect students from bias that's inherent in a system that is essentially mediating a claim. So the informal resolution process is a mediation, and I mediate these. And we never want students to feel pressured by a faculty or staff member's connection to an administrator, right? So it doesn't make sense to mediate those claims because there could be a power differential that's unfair to a survivor. So federal law recognizes that and requires that we investigate those independently and subject them to an independent decision maker. Does that make sense? Cool, I see people nodding. Okay, so the informal process, which again is reserved only for student v. student claims. First, a report is received. Then we have that cute little meeting where nobody knows anything, and I do not tell the respondent anything. And we explain the options. We find accommodations. We get them excused absences. We get them counseling. We get them anything that they need. And we give that student time and space to make a decision about how to proceed. Then, if they would like to informally resolve, we can have a variety of informal resolution meetings. They can be a mediation where each party is in a separate space, either physical space or virtual space, and I walk back and forth and ask the parties what they'd like. Do you want the other person to admit fault? Do you want them to be in trouble? Do you want them to undergo more training? Do you want an apology? What do you want? And then I take what that student wants back to the other student. And I ask them if they're okay with it. And we come up with a compromise. And we do that as many times as necessary. There's also, we don't necessarily arbitrate claims at Butler, but some institutions do allow arbitration, which is essentially like a trial, but more casual, where there's less rules and you just kind of chat about what occurred. But there's still witness testimony. So it's a little bit more formal than a simple conversation, but less formal than a hearing. We don't do that at Butler. I think it re-traumatizes survivors and doesn't make a whole hell of a lot of sense to me. So we just don't do that, but every institution is different. And we also do something called conversation circles, or many institutions refer to this as the Indigenous name, which is a peacekeeping circle. I myself am Indigenous and I love this practice, but essentially it is an open conversation where a talking stick or something similar is exchanged, and each party gets an opportunity to speak their mind about an issue until both parties feel as though they understand the other's perspective. What do you guys think? Is this appropriate for a rape allegation? No, probably not, right? Is this appropriate for a serious dating violence or domestic violence case, or really probably one at all? No, right? If there's a pattern of abuse, then if you put these two people in the same room, there's probably still going to be abuse. Doesn't really make sense. And so before we actually ask a student whether or not they want to informally resolve a claim, I usually do a risk assessment with the student to determine whether or not they feel as though they would be at risk doing so. And I'll show you guys that here in just a second. And then regardless of the method we choose, using an informal resolution technique, which can be any one of these few things that I've described, right? This is alternative dispute resolution. We're trying to avoid putting students through a hearing. A decision is reached. Both students will sign that decision and agree to its terms, meaning that one student may admit responsibility, one student may agree to be sanctioned, both students may agree to go to counseling, to but do volunteer work, to take additional trainings, to go to a One Love course or some other course on healthy relationships. But the students need to both agree to those. So do they have to informally resolve? No. Again, this is entirely voluntary and requires both students to consent to utilizing this method. And again, it's not appropriate for every circumstance. And can the student be sanctioned through this process? Yeah, and the university will recognize this. So if a student says, you know what, I will voluntarily agree to suspension. Okay, I agree to it. I don't know that that's ever happened at my institution since I've been there, but it's possible. If the student were to agree to that, right, the university would honor it as we would any decision. Does that make sense? All right, does anybody have any questions about informal resolution? I know it's a lot less common, so probably not, but I will take a second. Does anybody have any questions? Okay, all right, before we continue on, I'm going to stop sharing for just a second, and I'm going to actually pull up my Title IX handbook that I created for my institution so that you all can see some of these documents that I've described. And again, I'm going to make all of this available to you guys. Hold on one second. Okay. All right, so we are going to start with the intake checklist. This is the first document that we really use to, hang on one second, where is it? There it is. Okay, so this is the first document that we really use to evaluate a claim. Institutions have different documents that they might use for this, but this is really the information that we want to get during this first meeting from the student. So we're going to really ask them what the other party's name is, what the other party's role is, if there's police involvement, right? And we're going to take the time to explain to them that we are not going to call the police. In fact, there is never a circumstance except for one where a minor is involved, right? There is never a circumstance where I will call the police and file a report on behalf of a survivor and force them to speak to police. Not a circumstance. Unless that there is a minor involved and I have to, under Indiana state law, call the police and tell them there was a minor involved, I will never file a report for a student. They always have that choice, okay? So we want to get a basic incident summary. So from the student, from the survivor, not from the reporter, which are often different. We talked about that. Anyone can report. We want to get their summary of what occurred. Okay, then we go through this list. And I created this document to make sure that students, no matter who the person is sitting behind my desk, me or somebody else, but no matter who this person is, do you know everything you need to know as a survivor about your choices, your options, and what support you're required to have. And it's like a checklist. Did the survivor get a copy of the policy? Did the survivor get informed about the option to have law enforcement involved? Did the survivor get provided a list of the supportive measures that we can enact to protect them? Were they informed of their ability to file a formal complaint and that this is voluntary? Do they need medical attention? Were they explained that neither me, myself, or any student can retaliate against them for having this conversation with me? Do they understand that? Were they told about an advisor and their right to have an advisor, which is like an attorney, present during this process and at any meeting with me that they want? Were they told about the confidential support that we have on our campus and that this process is entirely confidential? And then we go as far as to say what their options are and explain them to them. Okay, so this is the first document that we actually use in this process, and every institution has a similar one. And now I'm going to show you the next piece. There are two more documents I want to show you guys. This one is our supportive measures tracker. This is actually how we keep track of whether or not survivors were provided with all of their options in terms of support. So we can issue no contact directives, which are like university restraining orders. I can keep two people from ever being in the same class. I can change their parking. I can change their housing, right? Were the students provided with that option? Were they provided with options about academic supportive measures? So extensions, absences that are excused, changing a course, a late drop of a course or a late add of a course. Were they provided with an option about maybe taking an incomplete or withdrawal? Were they referred to counseling? Were they referred to medical health services? And then our victims advocate on our campus, her name is Jules Grable. I don't know if she's present, but she's an active member of ICESA and is amazing. Were they told about her? And we actually go through this checklist with students, ask them if they need this, make note that they do need it, and ensure that we do it same day. Okay, and then, hang on one second. And then one more document I want to share with you. Okay, so this last one is our emergency removal assessment. This is how we decide if we are going to have to move forward without student consent. Okay, so I told you it's very rare that we would pursue a formal investigation without student consent because the process is entirely voluntary. I gave you two exceptions where the student is an immediate risk of physical threat or there's an immediate risk, right, to that student's safety. Immediate, meaning that student is about to be hurt right now by this other student. The only other exception is if there's a pattern of behavior such that the campus community at large could be at risk. And here are the questions that we ask ourselves to make that determination. Has physical violence been alleged? Are there threats of physical violence? Is there a weapon? Is there use of a date rape drug? Is there use of any type of drug for the purpose of achieving the other person's incapacitation? Okay. Is there an unequal power differential that could be replicated, right, in other relationships? We're thinking here about the campus community at large. Are there other reports of prohibited conduct? So do I have 3 pending cases right now about this same respondent? That's a good example. In that scenario, I probably have to add this complainant to the list, right? And then, is this pattern of conduct one that would subject the campus community to harm? Could it? So is this, are these violent sexual assaults? Is this, saying an inappropriate word to every woman that you see, right? Is it a risk of harm? Actual harm? Not that hearing an offensive word is not harmful, but we all kind of picking up what I'm putting down here. Okay, so again, I am not trying to keep the process behind a veil at all for any reason. I am in no way ever trying to keep anything from you all. So those are a look at some of the documents that we used for these 2 points in the process. So deciding between informal and formal resolution, evaluating whether or not a case is appropriate for formal resolution and formal investigation, even if the student doesn't want me to. And then, right, ensuring that our students have access to those supportive measures. And this is, right, these are the crucial points in this process in making the decision, providing student support, and actually starting the process. Does anybody have any other questions? And there are lots of other documents in this handbook. There's a template investigation report that will show you the types of information that we collect. But ultimately, you know what I mean? You all will have time to look at that, so I don't want to waste any time on that. Do you all have any questions about any of this so far? And then I'll go back to my PowerPoint. Okay. All right. Okay. So, okay, so this is where we left off. So Let's talk about when cases get dismissed. Even if a student tells me they want to move forward, can a case still get dismissed? Yeah, it can. There are really two situations where a complaint can be dismissed without the complainant's consent. The first is that the student, the respondent, unenrolls. It is possible just based on the institution, not necessarily at our institution. We actually permit these cases to continue, even if the respondent unenrolls. Our goal in that is to achieve a decision and to prohibit students from avoiding a decision by transferring, but not every institution does this, and you are not required to continue a process if a student unenrolls. The second one is no policy violation is alleged. So here's what I mean by that. I don't mean I believe this person, I don't believe that person. I never get to make that determination. Not ever. The question is, if I believe everyone, is the complainant alleging something that is prohibited by our policy? Right? So a good example is viewing one's Instagram story every day. Is that stalking? Our students often think it is. It is not. So although those are valid allegations, and I may not be making a determination about whether or not I believe that's occurring, it is not, even if true, a policy violation or a violation of the law. Does that make sense? So those are the only two situations where it can be dismissed. And yes, there are some situations where there is genuine trauma in a complainant, but the scenario isn't covered by our policy. A good example, often students are in consensual relationships with people and they feel as though they were manipulated. And I don't mean coerced. I just mean the relationship was perhaps not abusive, but not necessarily healthy. There's probably genuine trauma in that. In toxic relationships, even those that aren't abusive, there are going to be trauma responses. Does that mean that there was a policy violation or abuse, even alleged? No, right? Arguing every day, that's not abusive necessarily, and it still results in trauma. And so being cognizant of the fact that a lot of these students have genuine traumas that are related to things that I can't do anything about is very important. And we still like to provide students with the same accommodations and supportive measures as we would a student who's actually following the process, if that makes sense. Those supportive measures are available to any student who's the subject of any report, okay, regardless of whether or not I can administer either the formal or informal process, okay? So, Kelly asked, do you know how often students go through the process of filing police reports and working through the criminal process while also navigating the Title IX process? It's extremely common. Often the police report will result immediately. So an assault is occurring, someone calls the police, especially a neighboring dorm or something, the police get called, the police call me. If it occurs on our campus, the police call me, they tell me something's going on I need to know about. We file query forms and I input the report myself. It's extremely common. What's less common is a student following through on the criminal process during a Title IX process. The percentage, as we all know, of students, not just students, but even less for college students, the percentage of survivors who participate in the criminal process and seek criminal outcomes for their accused is very low. Survivors do not often, right, follow through on criminal complaints. It's jurisdictionally worse, even in our region, than other regions. And statistically, I would say 1 in 10 at my institution of students who do file initial reports follow through on charges. If that makes sense. I don't know if that's helpful or not. Okay. Okay, so what are the potential outcomes? What can result from either formal or informal resolution? Probation, suspension, expulsion, additional training, volunteer work, activity restrictions. So you can't be in that fraternity, you can't be in that sorority, you can't be in that club anymore, you can't be caught drinking on campus, those types of things. can all result from a Title IX process. It can be creative beyond this, guys, but this is a list to give you a good idea of what we can and have done. Okay. Okay. What are the differences between civil and criminal court and Title IX? Okay, and before we get into this, I'm going to just take one more break for questions. And actually, I'm going to really quickly check on my spawn if everybody takes 2 seconds.
We can't hear
Sure.
you. Sorry.
I was just reading the question, which I think everybody can see, but what input does the complainant have in the determination of sanctions? So none. Unless it's informal resolution, the complainant has no input. They are given the opportunity to provide an opening statement and a closing statement during the hearing, and I always encourage advisors to coach them on asking for specific sanctions, because I've just found that in practice, decision makers will often give some sort of merit and weight to what the complainant wants, but logistically and procedurally, they have no actual say. I would encourage them to speak their minds though, because often it does make a difference, if that makes sense. Okay, so what are the differences between Title IX, civil restraining orders, and criminal court? For those of you who don't know, I was a practicing attorney for several years before I became a Title IX coordinator, and my specialties were Title IX and civil rights representation and the representation of survivors in both civil restraining order cases and criminal cases. So I have done a lot of these and feel pretty confident that I can tell you what the differences are at this point. So Title IX, which is our top bubble here, in Title IX, there are no rules of evidence, and a Title IX case can never result in criminal charges. Title IX decisions, let's start with that one. Title IX decisions are completely confidential and are shared only internally and as necessary to implement the sanctions. Meaning, when I have a final decision, I might share it with the registrar's office if someone's being dismissed or put on, suspension or probation, maybe the dean of students, but that's it. Okay, nobody's mommy gets called, nobody's daddy gets called, no professors are told, right? No police are told about this. It stays with our administration and only those who are necessary. All right, so that's cannot result in criminal charges. Now, no rules of evidence. How many of you guys have heard the word hearsay? Guess what? That is not a thing in Title IX. It is awesome. So if somebody said something and that person said something, guess what? That's in now. Now, decision makers can make weight determinations, meaning they can decide how much weight to give that type of evidence, but federal law requires decision makers to consider all relevant evidence, all of it. So things that would normally not be considered in criminal court, like text messages, Facebook messages, social media messages, those almost always get thrown out of criminal court. Guess what? Those are in Title IX. We will rely on that. TikToks, we'll play them. Okay. Snapchat messages, you think that stuff is gone? It's not, it's in. Okay. Best part, as of January of last year, witnesses do not have to testify at the hearings. If your witness writes a statement, they send an email to the investigator stating what happened. They get on the phone with the investigator and they're like, this is what happened. And that gets included in the report. That's enough. That's evidence. That's that witness's testimony. Even if they can't testify, that testimony counts and must be considered. This is completely different than other courts. This is literally, this type of evidence would be considered hearsay within hearsay and would never be considered in either civil or criminal court. But federal law has said, you know what, we want to give universities the right to rely on statements from students who may not have the time or who may be scared and can't participate in these hearings. We want to make sure that that evidence is still considered because our goal is to protect, right? Protect. So all that stuff gets considered. It's amazing. Send me all of it. You have no idea how many weird screenshots I have gotten in the last 72 hours. Okay. It's great. We love that. Okay. So what happens in civil restraining order cases? They can result in criminal charges, right? The point of a civil restraining order is to create a blockade with which you can hold someone criminally accountable. That is not possible with Title IX. That is the major difference between the two. These standards of proof are the same. So in these two bubbles, the more likely than not standard, that's the same in both a civil restraining order case and a Title IX case. The question that that court and that our independent decision makers ask is it more likely than not that this occurred? That is it. 51% is all we need. 51%. Do I need 90%? Do I need to be sure? Nope. 51%, more likely than not. And in both, our survivors get the choice about how they proceed. A civil restraining order case is civil in nature, meaning one person versus another. A Title IX case is civil in nature, meaning one person versus another. Okay? The difference is civil restraining orders go on a public record. Title IX cases never see the light of day. Okay? All right, so what about criminal court? There's a much higher standard of proof in criminal court. It is beyond a reasonable doubt, beyond a reasonable doubt. We don't have that in Title IX. It's just 51%, right? It's not 90%. It's not 99%, which is what it is in criminal court. It's 51%, much higher in criminal court. Criminal court often takes a lot longer. It can be several years before a case reaches a trial, if at all, right? And unlike in criminal court, in Title IX and civil restraining orders, the complainant has a say. Okay, they have a say over whether or not they want to keep going. If it's an informal resolution for Title IX, they have a say over the outcome, right? And if it's for a civil restraining order, they always have a say over the outcome, right? So what is that student seeking? What is that survivor seeking? That matters in both Title IX and civil restraining order. It does not matter in criminal court. They will do what they want. You might say that you were raped and they charge them with something completely different, right? Sexual harassment or touching for sexual gratification or something weird, right? Nothing to do with what you said. Not your choice, unfortunately. Will they try to listen to you? I mean, yeah, it depends on which prosecutor you draw, right? But it's not, they're not bound to do what you ask, right? They're not even bound to give your choice any weight. Okay, but what is the similarities? What are the similarities between all three? And I couldn't fit these things in the little triangle, but these three right here in the middle are meant to be for all three. So there are three things that the processes have in common. There is a cross-exam. We've talked about how it is different between civil and criminal court and Title IX. Title IX requires that independent decision maker to break before the witnesses answer to make sure that nobody gets harassed, but there is nonetheless cross-examination required. There is going to be a hearing and trial for all three. And the most important piece, there is only one rule that exists evidentiarily in Title IX, and that's rape shield. Rape shield is the only rule of evidence that we have, really, and it's not even construed as a rule of evidence, it's construed as a relevance restriction. But it is the only rule that we have with regard to the types of evidence or the types of considerations that our decision makers can have. And if you're not familiar with rape shield, what it essentially says is that one's sexual history is in no way relevant in determining whether or not they've been assaulted and should not come in and will not come up. Our institution has actually extended that to one's sexual orientation as well. So that is not relevant. Not a topic of conversation and should not come up. But every institution is different in that vein until October when it will be required. But until October, it's a free-for-all. So does anybody have any questions about this? About a difference they've seen? About a similarity they've seen? Can all three processes be happening at the same time? Yes. As I've said, I have actually advised students, hey, go ask your attorney if you need to get a restraining order. And I've actually given students a printout of the website where you can go and do it in Indiana yourself. Okay, so students often have restraining orders, and when they provide those to me, I provide them to law enforcement, and we are ensuring that we comply with those. Okay, but that is common. Do criminal charges often accompany this? Yes, absolutely. We have a federal legal obligation to defer to a criminal process if one is continuing. So in other words, if there's a trial about to occur, because that respondent has a Fifth Amendment right to plead the Fifth and not testify, right? Because they don't have to testify, that extends to Title IX, meaning they would not have to participate in our process. And because of that, they would be unnecessarily harmed by us continuing without their participation. Okay, because what we learn could be subpoenaed in a criminal court to use against a respondent. Does that make sense? So we are obligated to defer to a criminal prosecution if one is continuing to trial. And if the respondent has elected to not testify. Does that make sense? So it's kind of an if this and this and this occurs, then we will defer. If there is a criminal case happening and the respondent is participating and they're providing the same information to both, and they have asked for us to cooperate with law enforcement and they intend to continue, then we'll continue, so long as we have consent. But if that respondent wishes to exercise their Fifth Amendment right, they have that right to do so. Does that make sense? Blame the Supreme Court if you don't like that one. Sorry, I don't like it either. It makes these things take forever. But I will say that the criminal cases that proceed to trial, as we all know, are very rare. I don't know what the stats are for Marion County, but most criminal cases result in settlements, plea deals. Does anybody have any questions? Okay. Okay. Oh, I had a whole slide for this where I was going to say what I just said. Wow, guys. Okay, so often cases will have all three components. And again, this is just being repetitive, but we will defer to criminal, but we do not ever defer to civil. So if you have a civil restraining order hearing in Marion County and you have a Title IX process, we're not going to wait until your hearing's over. We're going to keep going. A civil restraining order case is not one where a respondent is entitled to an attorney and is afforded the protections under the Fifth and Sixth Amendment, and as such, we are not required to defer. Does that make sense? That was a bunch of legal mumbo jumbo, but I realize that now that it came out of my mouth. So to rephrase, they are not permitted to plead the Fifth and remain silent during a civil restraining order. They can be quiet, but it can't be used to protect them in any way. They are also not entitled to be appointed an attorney in a civil restraining order case. They are also not entitled to a jury trial in a civil restraining order case. That is what I meant by those lack the Fifth and Sixth Amendment protections. So we do not defer to civil restraining order cases. If a case has all three, student support becomes our primary objective. Because I may or may not have to defer to a criminal case, student support will be my primary role. Meaning, how do we ensure that we're safety planning? Do we need to consider emergency removal of a student? So I looked at that spreadsheet or that checklist with you guys earlier. If all three are happening, there is a significant chance that that student is in imminent danger if the other student is on our campus, right? A significant chance. If that's the case, do I need to remove someone? Right? That's a conversation that we need to have. Is the student parking close to campus? Do their housing arrangements need to be changed? Does this person know where they live? These are the considerations that become of the most importance when we have a student who is going through all these three processes at the same time. we do have a question. With the amount of time criminal cases can often take, if a student graduated by the time that it's done, what happens with the deferred Title IX case? As long as it was filed when these students were students, we continue. And we can, like I said, at my institution, we can actually revoke diplomas if necessary. So if they graduated with a diploma, they can have that revoked. Civil restraining order is a civil protective order, yes. Every state calls it something different, and we actually have a few different forms in Indiana of civil protective orders, so I just lovingly refer to all of them as civil restraining orders. Since all these processes can be happening at the same time, how common is it for students to also engage with community-based victims advocates from rape crisis centers who can support them while they file police reports, seek protective orders? Any thoughts on how community-based advocates can make students aware of the services? Yeah, so we give out your all's information, but I would encourage you, and I have a slide on this, actually it might be the next one. No, it's not. Okay, here we go. Okay, so there are a lot of things that you guys can do, and it's very common that we see community-based advocates. A lot of these incidents are not covered by Title IX necessarily, and if they are covered by Title IX, they might be covered by a different institution, so you might be working with two different coordinators. I say all of that to say community-based advocates and our involvement with you guys is actually pretty common. I have a lot of victims advocates who come to us often from, you know, working with a student on Christmas break. A student goes home, goes to a crisis center, meets with an advocate, and that advocate becomes their person, right? Their confidant. And we see that a lot. And because I don't have them all the time, your all's role is going to be super important because you go where the student goes. I don't, right? I stay at Butler University in my office. And so you being accessible to the students when I'm not accessible or when that student isn't on our campus is really important. I'm going to walk you through what you can do, Kelly, which I think is kind of the answer to your question, but walk you through what things that you can do. So you want to do regular check-ins with a coordinator. Consider and ask coordinators about becoming an advisor. Advisors do not have to be attorneys under federal law. They do have to have training, but every institution offers training. Mine is a PowerPoint where you sit and hang out with me and I go through everything that I've just done with you all and maybe a little bit more. And you can be an advisor to a student, meaning you can do that cross-examination. You can represent the student and you'll get the training totally for free in order to do so. At our campus, we actually have a partnership with the IU McKinney School of Law, and we actually provide our students with law student representation completely for free. That's something that we are doing for other institutions as well. So if you're working with a student who's at another institution and they want an attorney or they want someone that's almost an attorney, still send me an email, right? We can find somebody from the law school to volunteer for your student and make sure they feel safe. Or you can do that role, but make sure that your student understands how important it is to have an advisor, right? Which is our version of an attorney, but it doesn't, again, does not have to be an attorney with them. It's going to be super important to have this person or you guys with them at all times. If you become involved with one of these cases, go ahead and reach out to the coordinator and ask for all the materials. Everything that I just sent or I just showed you all, and there's more, I'm going to send it to Kelly, but everything that, I just showed you guys should be available to you. There is no federal law that prohibits you from asking and from them giving you internal documents that explain how the process works or template documents that they use in the process. Okay, those are not confidential. They're not. So go ahead and ask for that information. Chances are, coordinator probably has never been asked and they'll probably give it to you. And then suddenly your survivor knows what to expect. Right? And that's a helpful step in the process. Open the lines of communication, send an email. Don't be afraid to reach out. Because of FERPA, we might have to ask the student to give us permission, but so long as the student gives us permission, we can talk to you. And sometimes you can be a really helpful go-between, like an advisor, right? To explain to the student where we are in the process and support them, finding ways to provide that information to them that are more trauma-informed, when I necessarily can't be trauma-informed. Right? Be the person that gets to say, I believe you. I can't say I believe you. I wish I could. I can't. I legally cannot. I am required to be unbiased and to tell them both that I don't know what the truth is and don't necessarily care. Is that true? Do I always not care? No, I always care, right? Do I sometimes know what I think the truth is? Almost always, but I can literally never say that. So be that person who gets to say, I believe you. Be that person who supports these students, because in that way, because often we cannot. And then ask for the policy, download the policy, go through it with your student. They should have been provided a copy under federal law. Go through it with the survivor and see if there's any piece of it that they don't understand, and send those questions. Don't be afraid to ask the questions. So I skipped through this because I know we're running out of time, but just so you all understand, we literally cannot take a position on these cases, and it is really hard. It is the hardest piece of our job, and that's going to make us appear cold. It's going to make us sometimes feel or appear not supportive, but we are supportive. And if you ask for the student support on your survivor's behalf, we will provide it, but you have to ask. Okay, and then there's one more thing. So I'm going to leave this up. These are the students' rights in the Title IX process, and I'm actually going to send this out. Kelly's going to send it out to you guys. But students have a right to accommodations, and it can be your role as a community-based advocate to ask for these. You all can ask for this information and hold coordinators accountable. If you don't feel like the student has been given extensions, excused absences, disability accommodations, or parking or living arrangement changes, you can ask for that. Don't be afraid to do it. And then I'm just going to leave this up and answer some of the questions I have. Okay, I have survivors K through 12 whose perpetrator goes to school with them, but the victimization happened outside of school or online. Frequently, when the school is contacted about this, they claim it is not their problem because it's not a Title IX violation. Woo! I'm going to send you some stuff. Emma, I'm going to send you some stuff. That's contrary to the law. That's not true.
Yeah, we have it very frequently up here, and I know it's contrary to the law, but when we're fighting these kind of big school institutions, we haven't been given a lot of like, what can we do about it? How can we make them see that it is their issue?
My advice, I would fill out an OCR complaint on the OCR website. I would attach that to an email and remind them that Title IX extends to online spaces, and that if you don't see some action, you'll file it. Anyone can file an OCR complaint, doesn't have to be an attorney, doesn't have to be a student. I would start threatening to do that. Yeah, that's vicious advice. Sorry, Marissa. Yeah, I don't mess around. If you're not following the law and you don't seem to have any interest in following the law, then you should get a complaint and have to be audited, because it is the worst thing that could possibly happen to any institution. Get audited. I wish for audits for this university or K through 12 space. Does anybody have any other questions? I know I've left like maybe 10 minutes for questions, and I want to answer anything that you guys have. Again, all of this stuff, I know this was like information overload, and I feel like I even tried to cut it down. I swear, Kelly, I really did. But I know this was information overload, and I'm going to send a lot of materials to Kelly. And listen, guys, if you ever need anything at all, if this ever gets confusing, just give me a call. It's no harm, no foul. I will always answer the phone. I put my cell phone number. Hang on one second. Here's my cell phone number and both of my email addresses. The one for the company that I run that actually does this very thing, and my university address. You can email either. You can call my cell phone. Do whatever makes you feel better. If you want to have a hypothetical conversation, we can have those hypothetical conversations. Yeah, okay, briefly summarize how the Clery Act and SAVE Act relate to sexual assault response and prevention. So Clery requires us to log criminal data. It does not include any identifying information. So some Title IX cases that result in allegations of domestic violence, dating violence, sexual assault, stalking. Those are really most of them. Any of those are crimes under federal law that must be clearly logged, not the identifying information, never the identifying information, but the fact that an allegation was made. That's what the Clery Act does. The SAVE Act requires us to educate all of our students on how our process works, what their rights are in the process, and what supportive measures we have or supportive resources we have on our campus. So it requires prevention, which didn't used to be a federal legal requirement, but now is. So the exact thing that I just subjected you all to, guess what? We get to subject all of our first year students to something very similar every year. They love it. They love it. And that's sort of how that relates, if that makes sense. Anybody else? And I know that this was a lot, so I will handle differently if it's a gendered school. Yeah, so gendered schools are an exception that does exist in private institution and is seen as a choice. It does not function differently though, because Title IX extends in such a way that it can still be gendered violence, even if perpetrated by the same gender. It would ignore and in many ways stereotype if it did not cover those scenarios, if that makes sense. So you can still be subjected to gendered violence. And by that, I mean sexual assault, sexual abuse, sexual harassment, even at the hands of your gender. And Title IX also covers, again, sexual orientation, LGBTQ status, pregnancy and maternity discrimination. What? Since 1972, by the way, it has literally required even voluntary termination of a pregnancy since 1972. For some reason, everyone's all in a tizzy about it only now, but it's been there. It's been there for a long time. All right. Is there anything else? Oh, yes, me too. My institution is proudly the first one in our region to have developed a pregnancy and maternity protection. Don't mean to brag, but it was more than a year before we actually had to do it. So yeah, now everybody has to do it. So make sure that your survivors know if they are with child or seek to terminate a pregnancy and have to travel beyond the state line, they are under federal law entitled to an excused absence with no questions asked. Yeah. Todd Rakita cannot find my address. So. Anything else? Okay.
Well, Georgia, I want to say thank you so much. I know all of our advocates, all of our Rape Crisis Center staff and service providers really appreciate this time with you. And I know there was a lot of questions, so if there are more questions, I can send them your way. You are the expert. I thank everybody for this. This will be recorded, so I will be sending out an email with the link to this presentation. And September 19th, we have our next Coffees with the Coalition, and that is a SART panel with different members of a SART. So we will see you then. Thank you all so much.